Good morning, everybody. This is the first of 3 lectures that I'm going to give you online that you can watch at home, basically on your own time, essentially with respect to the last 3 classes of the semester. So today I'll be talking about workplace law. Next week we'll be dealing with property law, and the last lecture, excuse me, will be on intellectual property. So this is the format that I'll be using. I'm going to be showing you the PowerPoint slides as I go through the lecture. So I'll bring the slides up, and then you'll see me in the top right-hand corner of your screen, and I'll be doing the lecture. The tests will go ahead as scheduled, so they'll be again on Wednesdays starting from 5:30 and running for 45 minutes. Because I can't see you to see if anybody is lagging behind at the end of the test, it's just automatically going to close off at 45 minutes. So please, basically time yourself accordingly, right? And likewise, there will be 3 tests, and then our take-home exam, I believe, our at-home exam is going to be on, I think it's April the 7th at 7 p.m. Again, it'll be exactly the same format as your tests and your midterms. So I'll be sending the email to you with your final exam, and you can do it, and then I'll have a fixed period of time for you to send it back to me. So having said that, let's start today's lecture. It's on workplace law, so that's chapter 9 in your text. All right. So give me a second, so I'm not, there we go. I'm sorry for the delay. I'm just getting used to this. Okay, so again, it's chapter 9. It's on workplace law, and we're dealing with essentially the law of employee relations, which is incredibly important for carrying on a business because most businesses have employees who basically do the operations of the business, and as a function of that, generate the profit for the business. So it's incredibly important that employers know how to properly treat their employees in the workplace. So workplace law includes human rights law, contract law, which you are already very familiar with, employment standards, health and safety, equity, privacy, labor relations law, which we're all going to talk about today, and tort law, which again we've done in a previous lecture. So torts are relevant to employee relationships as well. Obviously, again, understanding how workplace law works will help you carry on the business more effectively and hopefully generate more profits. So employment law. So employment is a contract. So again, you know what that is. It's a contract of service where a person agrees to work in service of someone else. And that is called, and it's a somewhat anachronistic name, but that is called the law of master and servant, and it still is called that. So in a lot of cases, older cases that you read as a function of the common law, which you guys know what that is, master and servant law is what's going to be referenced, which again is employee relations, basically. It's important to know that employment relations do not include dealings with independent contractors. So that means that if a plumber or an electrician comes to your house to do work on something that needs to be fixed, they're coming as independent contractors. So it's not an employer-employee relationship. So all of the obligations and the rights that flow back and forth between employers and employees do not apply. So they come to do the work in your house as independent contractors. The form of business that the contractors carry on, it can be anything that includes, again, as you already know, sole proprietors. It could be a partnerships, or it could be a corporation. So for instance, it could be J.L. Smith Plumbing Limited. It doesn't really matter what the form of the business enterprise is. It still is not going to be an employer-employee relationship. The employer, likewise, is obligated to provide employees with safe working conditions. This has been developed over a long period of time at common law but is now for the most part embodied in legislation that the provinces, because provinces for the most part have the constitutional obligation dealing with employment that they put in place by statute. There are some federal statutes that apply, and we'll talk about those. But for the most part, the laws that apply to employees and employers and how they work together are a function of provincial legislation. Okay? So employers have to provide a safe workplace environment, and they cannot require an employee to carry on a conduct that is unlawful. That not only means unlawful with respect to things like the criminal code, but it could, it also means things like, not doing things that are contrary to zoning bylaws or property standard bylaws or provincial offense. Basically, that so it's anything that is basically improper. So employers cannot require employees to do things that are outside the law to a great degree. Obviously, the employer is required to pay an agreed upon wage for the work performed by an employee. So obviously wages are the centerpiece of this relationship. The employee is obligated to carry out the reasonable instructions of the employer. And although this seems kind of old-fashioned, it's absolutely true that the employee must carry on their business with the employer in an honest, courteous, punctual manner, and in the best interests of the employer, who obviously is paying them a wage for doing this. So we have the common law as well that deals with this relationship. And again, employees and employers together have to act with honesty and good faith in the hiring process, which means that employees have to be truthful when they're applying for a job. They can't overestimate their skills. They can't hide things that the employer asks them about. So for instance, if an employer asks if you have a criminal record, you have to divulge that. Essentially, it's not something that is protected under human rights law. We'll talk about that a little bit later. So you have to be truthful in that regard. And likewise, the employer has to be truthful in the hiring process for the employee's safety, for the most part. So an employer can't tell an employee that carrying on the business of the employer is less dangerous than it may well be. So there are certain professions where there is inherent danger. For instance, window washing and climbing heights, or working again in mines, all those kind of things, or working outdoors in most jobs. There's some element of danger, so an employer has to be honest about that. and if they're not, then both the employee and the employer have actions against the other for negligent hiring, right? And that's a tort. There also has to be due diligence in hiring with respect to things like covenants. Covenants are terms, you know what those are, terms in a contract that are fundamental to the contract. So they have to be lived up to, and we're going to talk about what the individual covenants can be in the hiring process. And again, if something is not done properly or is done carelessly in the hiring process, then it gives rise to negligent hiring as a tort. Okay, employment contracts are just as you expect them to be. They are contracts. You know all about contract law. So they require an offer, they require an acceptance, and they require consideration. The consideration is going to be the wages, obviously. The covenants, the restrictive covenants that can be in an employment contract can be the following, but for the most part, they don't show up in a lot of contracts because people who enter into these kind of covenants are those that pretty much have special skills that they bring to the job or they acquire on a job. So things like non-competition clauses, which means that once an employee leaves the employ of whoever they're working for, they can't either work for another business that competes directly with their former employer, or they can't set up their own business and compete directly. So that's non-competition. The case law, again, the common law, has established over time that these kind of clauses can't go on forever. So somebody who has gained a certain amount of expertise in a certain field isn't going to be forbidden from carrying on a business and employing that expertise themselves for a long period of time. So the outside limit for most of the restrictive covenants that are non-competition clauses is about 5 years. That's right. So somebody may leave an employer and not compete for a period of 5 years, but after that 5 years goes by, then they are at liberty to basically create their own company or work for a company that directly competes. You also have what are called non-solicitation clauses. So again, these are clauses where somebody leaves an employment and is working for somebody else or on their own, and they don't go after the clients or the customers of their former business. So they don't solicit business that belongs to the employer, the one that they've left the job for. So again, that's a fairly common clause for somebody who is, who has special skills. This applies, even in people who work in the sales force, who obviously the backbone of being a salesperson is to create what's called a book of clients or customers. So they essentially can't take their book with them and then solicit those customers or clients for their new business that they basically made the contact with at the old business. And you also have what are called non-disclosure clauses. They're called NDAs. So NDAs basically mean that you can't go into a new business and disclose certain types of information that you gained in the former business. So it doesn't mean absolutely everything that you learned or became aware of in the old business is not going to be disclosed. It's going to relate to important kinds of information that are relevant to the successful carrying on of a business. So NDA clauses can go on, they're not restricted to say 5 years, they can go on forever. So that's an important consideration to have when you go to work for somebody else, that you're going to be bound by any one of those three or more than one of those three types of restrictive covenants, basically. A party who is unhappy with an employment contract can challenge that contract on a couple of grounds. The first one is that if there's what's called a change of consideration. What that essentially means is that if the employer changes the nature of the duties to be performed by the employee, i.e. makes the job more difficult or requires a higher level of training, all those kind of things, then if the employer doesn't provide additional wages, right, doesn't change the consideration, then the employee can seek relief for that. Obviously, an employee isn't going to sue their employer unless they've left their employ, because obviously you're not going to sue the boss you work for. There is also, there are also going to be challenges within the employment context for things like failure to meet minimum statutory standards, which are found in things like the Employment Standards Act, which we're going to talk about a little bit later. Okay, there are a number of ways to end the employment relationship. You can have resignation, which obviously is the employee giving notice that, in fact, they are going to leave the employee of their employer. Just like employers are required to give notice to terminate somebody, we'll talk about that in length in a few minutes. Employees have to give a reasonable notice to the employer that they're leaving, or they should do that. There's, so if an employee just, calls up at 9 o'clock one morning and says, yesterday was my last day of work, I'm not coming in anymore, that's unreasonable, and an employer could sue the employee for whatever it costs them to, for instance, train somebody quickly to take over their job if that's if the job requires a specific kind of knowledge. That's possible, but in the vast majority of cases, employer is not going to sue an employee if they leave a job, because they can probably be relatively easily replaced. Retirement obviously is a common way that employees leave employment. The age for retirement used to be 65. It used to be mandatory across the board to be 65, but that was challenged under various human rights codes and was struck down. So there is no longer any mandatory retirement age at 65. However, the courts have held that certain sectors can still put a mandatory retirement age in place if they believe that beyond a certain age affects the mental acuity, I guess, of somebody who's working. So, for instance, interestingly enough, the Supreme Court of Canada has a mandatory retirement age of 75. So you can't be a justice on the court beyond that age. Uh, if the reason for that is because the federal government doesn't believe that justices of the Supreme Court are still mentally sharp, let's say, at 75, that's probably not necessarily true. If there has been examples, for instance, where justices who, even before they reached 75, who had early onset dementia, and there's been actual cases of this, that they've retired voluntarily from the bench. But for the most part, at 75, most justices are still relatively in their prime when it comes to what they do, which is an incredibly important function in the judiciary process. Interestingly, in the United States, the Supreme Court has no retirement age, and so you have justices like Ginsburg, who is pretty much 90 years of age, who's sitting on the court. And she absolutely refuses to retire until Trump is out of office. And the reason for that is as follows. In Canada, even though justices of the Supreme Court are chosen by the Prime Minister in power at the time, so currently it's Justin Trudeau, and prior to him was Stephen Harper. So now we have a Liberal. Before that, we had a Conservative. When justices are appointed to the Supreme Court of Canada, there really isn't a lot of political connection to that appointment. They aren't expected necessarily to render judgments of one political ideology or the other, whereas in the United States, it's exactly the opposite. They are totally expected to be appointed by either Republican or Democratic presidents and rule based on political ideologies. And so, for instance, Trump has appointed two of the most recent openings in the United States Supreme Court, who are in fact very conservative judges, and he does that very specifically because he wants conservative judges on the bench. So Ginsburg, who is a liberal, so was appointed by a Democrat, even though she's clearly made it evident that she's very tired of being a judge. She's done it for decades at this point. She's also said, without a doubt, that she is not going to retire and allow Trump to make another appointment of a conservative justice to the Supreme Court. All right, so that's retirement. Likewise, in Canada, senators have to retire at the age of 75. So, the federal government has a policy in place, and it's not across the board, but it almost is, that the employment with the federal government is going to end at 75, and that's been upheld by the courts, even though it has been challenged by those who reach that age and don't want to retire under the human rights codes, but that those complaints have failed. So 75 it is for the federal government. Likewise, you can be an employment relationship can come to an end as a function of termination. It can either be for just cause or it can be wrongful, and that's incredibly important. So we're going to talk about that. So wrongful dismissal is probably the largest area of conflict with respect to master-servant, employer-employee relationships within the tort context, right? So outside any statutory requirements. And it involves a great deal of conflict because somebody usually has been fired, and they believe the person who's fired has been terminated unreasonably or without the appropriate cause. There used to be a show called I forgot what it's called, but it was basically The Apprentice, and Donald Trump in his earlier days, it was his show, and he would have people come onto the show, and over the course of the season, they had to do all the things that he asked them to do, and he would, every show fire somebody who was doing a task until the very end. He had somebody who he would hire, right? And the term always was, "You're fired." So having said that, nowadays he fires people at will without any particular reason. So there you go. So anyway, termination of employment for it to take place properly. So this is where an employer is going to end an employment for an employee. The employer has to give the employee what's called reasonable notice, right? Reasonable being an objective standard in the circumstances. So they have to give the employee reasonable notice, which simply means that somebody comes in, the employer brings them into their office, and they say, John or Jane, whoever it's going to be, your employment is now coming to an end. You have 2 weeks, 2 months, maybe even 2 years of further employment. But at the end of the period I've just told you, you're finished. Right? You have to leave your employment. An employer has to give that reasonable notice unless they have just cause, which essentially is wrongful conduct. And we'll talk about instances of wrongful conduct in a few minutes. But so it's either reasonable notice is given or just cause is given. And the substance of wrongful dismissal lawsuits is almost always that the employer has not given the employee a reasonable period of time before the end of the employment. All right. As an alternative to reasonable notice, and this is often done, instead of saying, John, your employment ends in 2 weeks or 2 months, I'm going to give you 2 weeks pay or 2 months pay. So that's considered to be what's called payment in lieu of notice. So in lieu means replacing. So payment replacing the notice. And, clearly if somebody is being fired, and obviously the employer doesn't want them to be there any longer, but they don't think they have wrongful conduct to rely upon or just cause, then more often than not, they're not going to want them around, because truly, how effective is an employee going to be after they've been terminated? They're really not going to have their heart in their job any longer. That's for sure. So the employer would very likely prefer to give them payment in lieu of actual notice. It's going to be a lump sum, so it's going to be a cash payment, and the payment in lieu is equal to the period of time that is reasonable for the termination. So again, if a 2-week notice is appropriate, then it'll be 2 weeks pay. If it's 2 months notice, it'll be 2 months pay, and the amount of that reasonable notice is determined by a number of factors. So again, it has to be reasonable. That's the standard in Canada. And these are the things you see on the slide that are taken into account in determining how long that notice would be to be considered reasonable. So things like the length of service by the employee, which obviously means that the longer an employee has worked for an employer, the longer the notice period should be. The type of job performed, that's really important. So, if it's, and the employee's qualifications, they kind of go together. So if the job is a somewhat unique job, or it's a upper management kind of job that has a lot of responsibility, then again, the notice or the pay in lieu is going to increase because of the importance of the employee. And as well, the nature of the job market is important. Now, for low-end jobs, not down near the minimum wage kind of area, the job market, for the most part, isn't going to be a consideration, because for somebody who's making minimum wage, they're likely not very well trained for the job, and they can certainly be trained easily enough going to another job. But if you're a key employee, in a managerial position, and you have very specific skills to take into a new job, there may not be a lot of those jobs available that you're qualified for because of your very specific skills. So if that's the case, then again, the time of the reasonable notice and or the pay, in lieu thereof, is going to increase dramatically depending upon the uniqueness of the job and therefore the limitations in the job market. And so the standard pretty much is, and again, this is the case law, is that if you've worked for a company for 20 years, which these days is a long time to work for the same company. In past generations, prior, like my father's generation kind of thing, a lot of employees, matter of fact, the majority of employees stayed with the same company for most of their working life. So an employee working for an employer for 20, 25 years was not uncommon. From what I understand, these days, the most recent stats are that people change jobs about every 5 to 7 years. And so, they figure they leave a job and go for a better one, obviously, over the course of their career a number of times. So, but having said that, if you did work for somebody for 20 years, then your reasonable period of notice for termination is in the order of about 2 years. Right? So that's a long time, and that's a really long time if you've been terminated and the employer decides to give you the notice and not the pay. So you're going to work for somebody for 2 years and know that your job is coming to an end at the end of that. In that kind of situation, employers pretty much count on the fact that the employee is going to pretty much start looking for a new job right away. And so it's highly unlikely they'll stay for the 2 years. They'll likely quit before that period is up because they found new employment. But having said that, if they want to get rid of the person right away, they're unhappy with them, but again, the conduct hasn't been wrongful, then they'll give them a lump sum, right? And if they don't do that, then this is the crux of the wrongful dismissal tort action. So the employee, will sue the employer for, the appropriate reasonable pay in lieu, which is going to be 2 years worth of wages. So that can be a significant lawsuit. So if you make $75,000 or $100,000, then it's a $200,000 damage claim against the employer. Obviously, less time or responsibility in the job will be a shorter notice and less pay in lieu of that notice. Again, if the employer has not done those two things, given the notice and or the pay, then the employee is going to sue for damages based upon what the appropriate notice would have been, right? The requirement for reasonable notice does not apply where there has been just cause, and I've said that a number of times already. And just cause is essentially termination without notice or lump sum, where in fact the employee has failed to live up to their obligations in the employment relationship. So these are the kind of things that are relevant. So if the employee does not have the skills for the job, that kind of thing an employer will likely find out relatively quickly after an employee is hired, because they're not going to be doing their job efficiently pretty much from the beginning of the job. So that'll be a quick termination with virtually no notice other than what's provided for in the Employment Standards Act. If an employee is careless or acts incompetently, which could take place during any period of tenure for somebody's employment, then that's just cause, or they act immorally or dishonestly. That's definitely just cause. That's wrongful conduct. They also can't be disobedient, which kind of seems like an old-fashioned term, but it's again, the case law has said that disobedience provides just cause. So in any of those scenarios, the employee can be fired without notice. This also includes, this is interesting, this also includes if you can't perform your job because you're sick or disabled. Now, having said that, yesterday, Premier Ford went on, basically he did a press conference so everybody would know that as a function of COVID-19, nobody will lose their employment if they have to be away from their job because either they're sick or they're quarantined in their home with somebody who is sick. So that is going to require legislation to amend the Employment Standards Act. So that's what they're doing. And the same thing for disability. So, and disability could be, more than just sickness. It could be other causes. So, everybody's being protected these days. An employer would be really hard pressed to fire anybody in the current environment in which we're in for however long this may last, weeks or months or longer. I have no idea. Nobody has any idea. But anyway, that's now protected. But prior to this particular pandemic taking hold, you could be fired if you were sick and couldn't do your job. Fortunately for employees, if that happens, they have recourse, again, as a function of legislation, to things like workers' compensation, which we'll talk about a little bit later. All right. Another important aspect of the employer-employee relationship, and we've talked about this a number of times in class, in other contexts, for instance, partnerships who have employees, that kind of thing. Employees, when they do things that are harmful or wrong, they bind the employer, so the employer becomes responsible for the actions of the employees, and that's vicarious liability. So we've talked about that quite a bit, so you guys understand that. So that allows somebody who is harmed by an employee or employer to basically sue that employer for compensation for those injuries. All right. There's vicarious liability as long as the employee, when they caused the harm, did it in the course of their employment or their job, right? So it has to take place, within the context of what they are supposed to do as an employee. If they were acting outside their employment, right? So they did something that pretty much had nothing to do with their job. They just strayed from their proper duties. Then there is no vicarious liability, and as a function of that, the employer is not responsible for the employee's actions. All right. This brings us to the first bit of legislation that's important with respect to the master-servant law, and that's the Ontario Human Rights Code, which in Ontario was put in place in 1961, the very first version of it. It was put in place 16 years after the end of the Second World War, which was the impetus to a great degree for human rights legislation and codes worldwide. Obviously, there were a number of atrocities during the Second World War, and even in Canada, there was discriminatory practices for things like the internment of Japanese Canadians. So during the Second World War, this is particularly in British Columbia, Japanese Canadians who were Canadian citizens, had been born in Canada, were interred, which means they were put into essentially not prisoner of war camps, but not much better, and their properties were seized just because they were, they had the ancestral connection to a country that we were at war with during the Second World War. To a lesser extent, that happened with Germans and Italians in Canada, who we were obviously at war with. So, over the course of the next 15 years, most nations basically put in place human rights codes to address discrimination. In 1948, only 3 years after the end of the Second World War, Eleanor Roosevelt, who was the widow of Franklin Roosevelt, who had been the president of the United States for about 15 or 16 years, from 1932 to 1945, when he died in office. She took up the challenge to create the United Nations Human Rights Declaration, as part of the United Nations itself, which was a function of what her husband had done during the war. So the United Nations was actually created in 1945. The instigation for the United Nations took place in January 1942, which was the month after the bombing of Pearl Harbor in Hawaii of the Japanese against the Americans, which brought the United States into the Second World War. And Franklin Roosevelt, in 1942 said nations have to come together and be united in addressing the inequities in the world, the danger in the war. And then when the war ended in 45, just before he died, the United Nations was created. And 3 years later, the Universal Declaration of Human Rights was passed by the UN, which is the genesis of all human rights legislation pretty much in the world, including, in our case, the Charter. So, and we'll get to that in a few minutes. But having said that, in 1961, Ontario passed the Ontario Human Rights Code, which has application, clearly within the province of Ontario. And what it did is it put in place a number of areas or topics which should not be those who have these as inherent in how they carry on their lives and in the workplace should not be discriminated against as a function of what you see on the screen relating to their conditions. So race, ancestry, place of origin, color. So the list that you see on the left-hand side of the slide, from race down to sex, and sex at the bottom here means gender. These were the grounds of discrimination that were protected in the first Human Rights Code in 1961, because this is now 50 years ago. These were the things that were considered, it's almost 60 years, sorry. These are the things that were considered to be important and not to be discriminated against. But what the Human Rights Code has done over the course of the last 60 years is that it has expanded these areas that are protected against discrimination. So most recently, things like gender identity and expression. So they've been, the Human Rights Code itself has been amended. And that's not necessarily a difficult thing to do, because it's really only a statute put in place by the provincial government. So to change or add grounds of discrimination to the Human Rights Code simply requires a bill to be introduced in the legislature at Queen's Park in Toronto. It has its 3 readings and then an assent by the Lieutenant Governor, and it becomes law. In the Charter, it's a totally different story. The Charter is a constitutional document, as you all know, put in place in 1982. Section 15 of the Charter is the provision that deals with discrimination. Discrimination, of course, in the Charter deals with actions by a level of government against you, right? That's what the Charter protects. And you'll see in the Charter that in Section 15, the grounds that are listed are only those that were identified as being important to be protected in 1982. So it doesn't have items like gender, expression, or identity, although they are now protected, but they are only protected as a function of the Supreme Court of Canada. So what the Supreme Court decided to do, and this is 15, 20 odd years ago, was that they knew that the Charter Section 15 wasn't going to be amended, because to amend it requires a constitutional amendment, which means 7 provinces with the population of Canada, no less than 50%, have to agree to it. So there are very, very few amendments to the Constitution, because that formula is rather onerous. The Supreme Court knew this and knew that if the grounds for discrimination in the Charter were to be expanded, it would have to be done by the court. So what the Supreme Court did is it did what's called, it reads in to the provision of the Charter amendments. So what the Supreme Court has basically said now is that you can read into Section 15 protection for things like gender identity and expression. So they are now protected in the Charter, just like they are in the Ontario Human Rights Code. And again, while the Human Rights Code can be continuously updated by the Ontario government, the Charter, for the most part, will be updated by the Supreme Court, unless the federal government wants to, again, engage in that rather difficult process of a constitutional amendment. So in this slide that you see in front of you, all those things on the right-hand side of the slide are pretty much things that the Ontario government has put into place since 1962 over the course of time. All right, the Ontario human rights system has 3 distinct parts to it that make up the infrastructure of human rights in Ontario. You have the Ontario Human Rights Tribunal, you have the Human Rights Legal Support Center, and the Ontario Human Rights Commission, and they all have different roles to play. So the tribunal, which is like a court, but it's a little less formal, the Ontario Human Rights Tribunal is there to receive complaints from those people who believe that they have been discriminated against based on those grounds set out in the Human Rights Code. And the tribunal is a very accessible kind of thing. And so when you file your complaint, it's called an application. It goes to the tribunal, right? And the tribunal will deal with it directly. And what they do is that they will decide how to deal with your situation. And they will actually get back to you relatively quickly and tell you whether or not you have a good case. Most of that deals with whether or not your particular complaint falls within one of those grounds of discrimination that we saw a couple of slides ago. Because if it doesn't fall within one of those grounds, then you don't have a valid complaint to go before the tribunal. And interestingly enough, the grounds for discrimination in Ontario is somewhat similar to most provinces and territories in Canada, but not identical. So there are differences depending on where you live in this country. So, for instance, in Ontario, one of the protected grounds against discrimination is that if you have a criminal record and it has either been suspended, the record has been suspended by the Parole Board of Canada, or prior to 2011, it was pardoned. So if an employer asks you if you have a criminal record, again, if it's been suspended or pardoned, then you don't have to provide an answer to that because that's protected ground of discrimination. And that's a really important ground these days because, you know, most employers, including McDonald's and Walmart, ask you for your criminal record check when you apply for a job, right? That didn't used to be the case at all. 10, 15 years ago, it was unlikely, it was highly unlikely to get that kind of request. Nowadays, it's a very common request. However, if you are looking for a job in British Columbia, under their Human Rights Code, they protect discrimination clearly if you only have, even if it's only a record you have, even if it's not been suspended or pardoned. So if you have a criminal record in British Columbia, that's a protected grounds of discrimination. So employers cannot ask you for a criminal record check or a background check because it's protected. So again, if you apply in Ontario because you think you've been discriminated against because an employer has asked you for a criminal record check and you don't want to give it because you have a record and it hasn't been suspended or pardoned, and you complain to the tribunal saying, I think I've been discriminated against, they're going to come back to you relatively quickly and tell you that no, that's not a protected grounds of discrimination in Ontario, and so your case isn't going to go forward from there. So that's a pretty useful function for the tribunal. We also have the Legal Support Center for Human Rights, which is to a great degree a legal aid function of, a legal aid function of human rights, which essentially means that if you don't have the funds to pursue your challenge, they will provide funds for you in that regard. So it's like legal aid for other matters, but the Human Rights Tribunal will provide counsel for you to proceed with your claim. And the third element of the infrastructure of human rights is the Human Rights Commission. So this is the policy-making body of human rights. So these are the group of people who sit and decide, importantly, what the grounds of discrimination are going to be. And that's really important. So this is the group that, for instance, 15 years ago would have said, you know, we think we should add gender identity and expression as protected grounds. So that's what they do. They do an overall policy perspective on human rights. So it's, for instance, the commission is not a body to which you would apply for a complaint. They have an overseeing kind of function in that regard. Again, remember that Ontario Human Rights Code deals with employment for jobs, you know, that for most jobs which are in the provincial sector. Canada, if you work for an employer that is a federal employer, then you need to look to the Canadian Human Rights Act, put in place by the federal government in 1977, which does the same thing as the Ontario Human Rights Code, but in the federal sector, right? So it's the same kind of thing, and the grounds are very similar for discrimination. We also have human rights accommodations in the workplace, which simply means if, for instance, you are the subject of any one of those grounds of discrimination that you believe affects your ability to carry on your job, then the employers are obligated to accommodate you in that position. So to a great degree, that applies for the ground of not being discriminated against with respect to a disability. So if you have a disability, things like deafness or blindness, there could be other physical disabilities and mental disabilities for that matter, the employer has to accommodate you in whichever way they can so that you can carry on your job in a competent and efficient kind of manner without being overly taxing as a function of your disability. So again, that's a requirement that employers have. The remedies that human rights violations can give rise to is on the list you see in your slide. So there can be compensation for lost wages if you've been terminated as a function of protected grounds. if there's been injury to your dignity, right? So, this could be a personal affront to who you are. If you were, and again, this may well apply for, again, gender identity and expression. That's a good example of it. If you've been fired as a function of your gender preference, then that could be a very personal affront to you, and you can get compensation or damages for that. The tribunal can also order things like your legal costs to be paid. They can order the employer to basically re-employ you, to rehire you, that kind of thing. They can make sure that the employer has to undertake awareness training, cross-cultural communications, sexual harassment training, or implement anti-harassment policies. And I can tell you that as a function of human rights and employment standards, that basically every employer these days has a policy on sexual harassment and anti-harassment. It doesn't have to be sexual, it can just be harassment itself. So they have policies that are clearly available to all employees, so they know what the process is in the event they believe they've been harassed for whatever reason. The process, and Algoma has this process in place. If the reason relates to any kind of harassment, then you basically take it up with your boss, or if in the event it's the boss that is doing this, their boss, that kind of thing. And there's a mediation process and a consultative process, and then other remedies that can take place if neither one of those kind of conciliatory things take place. Okay, so in addition to the common law with respect to master and servant, there are numerous statutes that have been enacted to govern the employer-employee relationship. So we're going to go through those. One of the most important ones, of course, is the Employment Standards Act, put in place in 2000. So it does things like it sets out minimum terms of things like how many hours a week, a maximum number of how many hours a week you can be forced to work. And if you work more than those number of hours voluntarily, then it sets out the rate of pay that you're to be paid, which is usually time and a half. It sets out things like the amount of time you're entitled to for lunches and morning and afternoon breaks, those kind of things. Minimum wages are set out in the Employment Standards Act. So every time a minimum wage changes, it's a function of the provincial government actually putting that change into place by way of a statutory amendment. It also requires employers to keep a very good record of an employee's employment, and that record will include any complaints the employee has made. Again, this involves harassment complaints, those kind of things, or any complaints that the employer has made and against the employee, including things like discipline. So, all employers are required to keep very meticulous records regarding employees, and these records are going to go to the Ministry of Labor. If, for instance, an employee has a complaint that it believes should be handled by the Ministry of Labor against the employer, then the employee's record will be made available to the ministry, so they have that to give some context to that relationship. We have the Occupational Health and Safety Act, which is incredibly important. This is something that, again, all employers, they have to put up a bulletin board in all places of employment that sets out the rights you have in the event of hazardous conditions being in the workplace. So, it sets out the employee's rights to participate in work, the employee's rights not to work in an unsafe environment, to stop work if the work itself becomes unsafe, and the right to know about workplace hazards. So again, as students, you should have a bulletin board in your student area at the university that sets this out. The employees at Algoma, including the faculty, have bulletin boards to this effect around the university as well. They are sometimes in prominent locations and sometimes not. So, that's a thing that the university dictates where they go, but the union overlooks it and ensures that at least some of these bulletin boards are located in a prominent location so employees can see them. This act also requires employers to report any workplace accidents to the Ministry of Labor, so that's incredibly important. If it's a significant kind of injury, then the ministry will actually send somebody out to do an investigation. So if somebody is hurt in a severe way, then there will actually be an on-site investigation. All employers have to address workplace violence and harassment. Again, as I said before, they will incorporate that into their manuals, their employer-employee manuals, which are going to be online for the most part. And anything that contravenes the act or any requirement that requires the intervention of somebody like the ministry regarding accidents and what have you, they are a strict liability offense. And you guys are familiar with this. We talked about this in our class on torts. So what that simply means is it doesn't matter whether the workplace accident happened as a function of intentional conduct, which is going to be somewhat unusual, but more likely an accident, so carelessness. It doesn't matter who was at fault or what the level of fault is. It's strict liability, meaning that they all have to be reported, right? So there's no level of fault that attaches to the accident. Every accident has to be reported no matter what, all right? We also have what's called the Workplace Safety and Insurance Act. This replaced the prior Workers' Compensation Act that we had in Ontario, which obviously takes care of workers who are injured on the job. So, this is incredibly important because, again, as we saw earlier, you can be dismissed from your job outside the current pandemic. You can be dismissed from your job if you are sick, and so as a function of the job. So if you basically do become sick now, you have recourse to workers' compensation, which will basically provide healthcare costs relating to the injury, which may well be things like therapy to help you, regain whatever or restore from whatever injury you've had. Loss of your wages are certainly going to be covered in compensation. Loss of retirement benefits if somebody is killed on the job, then there's survivor benefits or death benefits that go to the family who's left behind, those kind of things. Employers pay the full cost of this kind of compensation, right? So essentially that means that it's not a co-pay kind of thing, so employees don't have to contribute. For instance, employees have to co-pay for things like employment insurance and the Canada Pension Plan, but not for workers' compensation, so it's on the employers, it's on their dime, basically, to cover this. Workers' compensation, and we talked a bit about this, again, dealing with torts, came about as a function of the Industrial Revolution in the 1800s, and in most common law jurisdictions, it dealt with people working in environments that were incredibly unsafe. So for instance, in the United States, that included working on railways and working in mines, coal mines, for instance. And what was happening is that because they were so inherently dangerous places to work, there were a great number of employees who were suing their employers to basically provide them with some kind of compensation, because again, there was nothing else that would provide for their families that they could turn to. There was no legislation that provided help. And what happened is that these lawsuits were becoming so pervasive that the owners of the mines, the owners of the railways, which were very rich people, they were called barons, mining barons, railway barons. They were very rich people, very powerful people. They would know people in high places. They would know the president personally, that kind of thing. They basically, went to the government and said, look, you've got to put some kind of system in place. We'll pay for it, but you have to put some kind of system in place that provides some relief to these people so that they stop suing us. And so in fact, that's exactly what happened. The workers' compensation system started in the late 1880s, and by the 1920s, every common law country in the world pretty much had a workers' compensation system. And basically that system allows for relief for those workers who are sick or harmed on the job. So that's an incredibly important kind of thing to remember. Again, it's a no-fault system. This slide says that employers and employees pay into the fund, but that's just that originally it was employees as well, but now it's just simply employers that pay into it, right? And as a function of this system, when back in the day when the barons said, to the government, please help us put this system in place. What they also said is that if we're gonna fund it to a great degree, then what we expect is that employees no longer have the right to sue us. And that was the converse, or the quid pro quo, in putting that compensation in place. So in fact, if you are injured or hurt on the job, you have to basically go through workers' compensation. You cannot sue the employer over and above what workers' compensation provides. We also have equity in the workplace as a function of employment standards, which simply means that men and women should be paid the same amount of money for the same caliber of work. That's been in place now for over 20 years. Having said that, that's a relatively easy concept to live up to in low-end jobs, right? Minimum wage and just above that, because the jobs are pretty interchangeable and everybody's going to be paid the same. But having said that, in high-end jobs, key employee managerial positions, there isn't quite equity at this point. It's getting there, but it's certainly not there at this stage. So if you are a key employee for an employer, so you have very special skills, you're in the upper echelon of employment, so you're in a managerial position and what have you. The difference is essentially these days about 15%. So a man doing a key job is going to be paid 15% more than a woman doing that job. So for every dollar the man earns, the woman will earn about 50 or 85 cents, so 15 cents less. So that's not obviously in line with equity in the workforce, but it's the reality of things, but that is changing, all right? The next major issue to deal with the employer-employee relationships is that of trade unions and collective bargaining that goes with trade unions. The majority of the workforce in Canada belongs to a trade union. We're going to talk about how they're created and what they do for employees. So, again, everybody who works for General Motors or Ford, or I think Walmart now even, are in a union. I can tell you that all of the faculty and the staff at Algoma University are in a union. The students have an association. It's not a union, so to speak. I don't think the Student Association has a collective agreement. I'm pretty sure you guys don't. I could be wrong, but I'm pretty sure you don't. Algoma itself has 3 unions. It has, again, 1 union for staff. That's everybody who is not a member of the faculty. So, that includes, everybody who works in the registrar's office, who you would come into contact with, everybody who, has office functions or janitorial functions, all those kind of things. They belong to a staff union. And then we have another union called Local 685 of OPSU, Ontario Provincial Services Employment Provincial Services Employee Union, OPSU, and that is the union that the faculty has in place. It's been in place for about 3 years now. Prior to that, Algoma had just its own little faculty association, which was a union, but it decided to join OPSU 3 years ago to be part of a bigger union. And there are 2 separate units in the faculty union, one for full-time faculty and one for part-time faculty. And they have separate collective agreements. And again, I'll talk to you about that in a second. All right. If a union wants to be represented, if employees want to be represented by a union, then a vote is taken. And if a majority agrees, doesn't have to be unanimous. If a majority agrees to become part of a union, then in fact they can, unionize. That's what it's called. There are 2 ways to do it. You can create, these employees can create their own union. So that's called certifying the union. So they create a brand new union, and through the provincial government, it's certified under the Labor Relations Act. Or they can join an existing union, which is what, in fact, for instance, the Algoma faculty did. They went from being their own union or association to joining an existing union, which was OPSU. And so that's called certifying the vote. So you can certify a union to create a new one, or certify the vote to join an existing union. The union is, once it's formed, then it becomes what's called the exclusive bargaining agent for the employees that belong to the union, which means that all of the things that unions do for employees that deals with wages and benefits and standards of work, all those kind of things that are really important to the employee in the employment context, all of those things are handled by the union on their behalf with respect to the employer. So if something goes wrong, they don't like, they can't sue the employer. They have to basically file a complaint. It's called a grievance with their union, and the union will handle it. And there are union executive members, they're called stewards, who handle complaints for their members. So unions deal again with all things like wages, conditions of work, and benefits. So that's what the great majority of things are done by the union. Importantly, what belonging to a large union does is that it provides funding for things like legal costs related to arbitrations, which can be an incredibly expensive proposition. So if you belong to a larger union, you know that if you have a grievance that proceeds to an arbitration, those kind of things, that they will in fact be covered by union funds, which is obviously a great advantage over having a small independent union of your own. And that was honestly a really big reason why the Algoma faculty decided to join a larger union, to have the availability of that large fund to promote their interests. An employer is prohibited from firing an employee who is trying to form a union. So you can imagine that if a group of employees who aren't unionized have decided that in fact unionizing is a good thing, then there's going to be a process that takes place, including calling a vote for that majority consensus. So I guarantee you that employers are going to know that this is underway, because it does take time, and so employers are absolutely forbidden from firing employees who are starting that process. Right? So that's obviously a good thing. And the converse of that is that a union is prohibited from threatening or coercing employees to join the union. So when that vote seeking a majority to create the union is taken, there can't be any pressure on people who are going to vote to in fact vote yes to create that union. Again, once the union is created and the union becomes the exclusive bargaining agent for all its members, then its next job, basically, or its first job to a great degree, is to reach what's called a collective agreement, which is also called a collective bargaining agreement. They mean exactly the same thing. And again, an agreement, it's a contract. And it's a contract that sets out the terms of employment for the most part. Right? If the parties have a difficulty reaching an agreement on the terms of that contract, then the first thing that's going to do is that there's going to be what's called a conciliation. It's also called a mediation. So a independent third party will come in and sit down with both the management, which is the employer, and the union on behalf of the employees, and they'll discuss the issues that are relevant to what would become a collective agreement, and hopefully they can come to agreeable terms so that the agreement is entered into, or can be entered into, and then go forward. Collective agreements usually have a term, a fixed term. It could be 1, 2, or 3 years. 3 years is pretty much the longest collective agreements are in place. And usually they're more than 1 year, because you really don't want to be negotiating these things on an ongoing basis. So 2 to 3 years is the norm. And then what happens is, of course, is that in the last year of whatever the term is for the collective agreement, negotiations start again to revisit terms that may want to be amended by either management or the union. If the parties can't agree on a collective agreement, and this means the union is already obviously in place, then there can be a strike or a lockout. So a strike is what takes place when the employees leave the job. So a strike is an employee action. So they walk off a job. A lockout is when, in fact, the employer closes down the job. So they stop the employees from coming to work. For most of you, the only lockouts you would be familiar with or even heard of are lockouts, for instance, that have been put in place by the NHL against the Players Association, which is the union. So over the course of the last 25 years, there have been 3 major lockouts put in place by the NHL ownership group. So that's 30 incredibly wealthy individuals who are the owners of hockey teams who are represented by Gary Bettman. He's been doing this job for a long time, and they have locked out the players because they couldn't come to an agreeable collective agreement affecting, for the most part, wages and sometimes benefits of those players. And so they've locked them out for periods of time, which of course brings the hockey season to an end, which is clearly something that upsets a lot of fans. So there's a lot of pressure to come to an agreement. And I can tell you that over the course of time, the beneficiary of these lockouts has been the employers, not the employees. They tend to do, they've done better in the NHL context than the Players Association. So that's just a fact of life. But of course, lockouts can take place by any employers in any relationship. If there is a strike or a lockout, then what the employees do is they picket the job site. This also includes, one-day strikes. So you guys have all seen in the last few months teachers who've been picketing in front of public schools and high schools in Sault Ste. Marie. And so on those one-day strikes, they will do it in front of the schools. Sometimes they do it at intersections so more cars can see them than usual. And that's a function of the strike action. So they're picketing the job, which means that they're holding signs and waving signs, basically saying, here's our grievances with, and in the case of teachers, with the provincial government of Ontario. When picketing takes place, they can't do it on the employer's premises. So teachers can't do it on school property, but they can do it on sidewalks in front of schools. Likewise, in factories that are on strike, the employees have to go outside the boundary of the factory. And for instance, in Algoma, if either the staff union or either faculty union go on strike, then they would picket, for instance, on Queen Street. They would picket on Queen Street, basically outside that entrance that we have on Queen Street, so not on the university property. And they would also picket at the rear entrance leading, away from where Andrea McRae Public School is, right at the back. So they would picket both those entrances. And what they try to do as a function of picketing as well is that they try to dissuade people from going onto the properties. So that doesn't do much in the university context, but in companies that are profit motivated, they try to stop trucks from delivering goods. They try to stop anybody who would basically contribute to the ongoing business of a company, because when there are strikes, companies still try to do their job. They still try to carry on their business. They don't want to lose the potential of profits. They certainly don't want to shut down. So what usually happens with the companies that go on strike is that management personnel who aren't part of a union usually do what were formerly those unionized jobs to keep the business going. That's just the way it works, right? There's a practice amongst what's called affiliated unions that they won't cross a picket line for a period of 3 days. So again, in the Algoma example, while OPSU is the faculty union, it has 2 separate units, again, the full-time and part-time. So, and they're affiliated, but they totally act differently. They have their own units. They can go on strike independent of the other. They don't do it at the same time. So if the full-time faculty was to go on strike at Algoma, they'd be picketing out on Queen Street and at the back entrance. For the first 3 days, part-time faculty would not cross that picket line. Now, I can tell you as a function of being affiliated that members of the part-time unit would also not teach full-time courses, right? That's just something, that's just an agreement that these unions have. So, obviously that's important because there wouldn't be any real impact upon the university if part-timers taught full-time courses. Obviously, of course, the people who suffer the most in these instances are the students. And if you remember last year, the year before, community colleges in Ontario were on strike for months and it was a real problem. And you know, when it eventually settled, there was a whole issue as to, you know, are you going to, you know, are you going to try to complete your courses, these the students, in a condensed fashion, or are you just going to take them over again? You don't have to repay tuition. All those kind of things were relevant when community colleges like Sioux College went on strike for an extended period of time. All right. Pickets are permitted as long as they're peaceful. So even though, for instance, picketers try to dissuade vehicles or people coming onto property that, you know, is the subject of a strike or a lockout, they have to do it peacefully. They can't, you know, they can't, you know, physically try to stop access to the property. So if there's intimidation or violence, that's breaking the law. And what will happen is that employers will call the cops, essentially, to stop that kind of illegal picketing. So that's important to keep in mind, right? And lastly, once a strike or a lockout over an agreement is completed, or, you know, is ongoing but needs to come to an end, particularly with respect to things like essential services like police and fire, then what will usually happen is that the parties, the strike or lockouts, will come to an end, but for the purposes of coming to a new collective agreement, they'll go to what's called binding arbitration, which is very much like a court. It's not exactly like a court because you get to choose your arbitrator. But having said that, once the arbitrator is chosen, it becomes an adversarial process where the parties make arguments to the arbitrator as to the terms they want to see in the new collective agreement. And then the arbitrator will make a decision as to what the collective agreement will look like. And that's binding on the parties. And it will likely be binding on the parties until the next term of the collective agreement, whether it's 1, 2, or 3 years later, comes up for renegotiation. All right, guys, that's it for this lecture. Thank you very much for watching. Again, I will post your test for Chapter 9. I'll email it to you Wednesday at 5:30, and you have 45 minutes to complete it. And then next week, I will do a lecture just like this on the law of property, and the same thing for the test. And I'll obviously talk to you about your final exam some more before we get there. Okay? Thank you very much, guys.